Hello to all the colleagues. For anyone I haven't met, I'm Helen McCara from the New Zealand Merchant Service Guild. I'm really sorry I can't be there with you all. I cancelled my travel to Brussels when that city went into lockdown, and so that meant I couldn't attend this meeting. But criminalisation is a really important issue for all of us, and thank you to Brother Mark Dickinson and to Charles for organising this meeting and for making criminalisation the first topic for discussion of the Jason project. I've also read George Quick's excellent paper, and we 100% support and agree with all the concerns raised in that paper. So I've sent you a presentation of just a few slides about the New Zealand experience with criminalisation. As you know, New Zealand is so far away from anywhere in the world. If you're flying from London, you get to Singapore and you've lost the will to live already, but then you have to do another 11-hour flight to get to Auckland, and the next stop is basically Antarctica. The country's small. There's two main islands separated by a Cook Strait, named after Captain Cook, who charted the New Zealand coastline in the late 1770s. But the ocean area around the country is about 15 times the size of its landmass, and the fourth largest EEZ in the world. So this makes New Zealand very dependent on shipping, but the local maritime industry has been allowed to decline to almost nothing. Just like Australia, we have only 15 ships under the New Zealand flag now, but 90% of our goods are imported and exported on FOC vessels that are in transit to other ports around the world. So the law in New Zealand is based on English law, but it's underpinned by the Treaty of Waitangi, which is an agreement between the British Crown and the indigenous Maori people, which was signed in 1840. So the Crown doesn't participate in the legislative process, but the principles of the treaty are important and must always be taken into account by Parliament when it creates the laws. This is particularly important in environmental legislation, and so in that legislation there's a doubly strong emphasis on protection of the physical and environment and recognition of the treasures of the natural world, including the sea and the seabed, which are guaranteed to Maori under the treaty. So there are dozens of criminal offences in our law which apply to the master of a ship. There are numerous others aimed at any holder of a maritime document, which includes a certificate of competency. The most commonly used offences are those contained in the Maritime Transport Act of 1994, which has recently been comprehensively amended. But there are also other offences in the Crimes Act, the Resource Management Act, and the EEZ Act, and many other acts. The Maritime Transport Act offences don't specifically refer to the master, but it's most likely that of the crew, the master will be the person responsible for the operation of the ship, and therefore the most likely to be charged with the offence. So the offences can basically be put into 4 or 5 groups. They're all strict liability offences, and there's no requirement to prove mens rea or intention. The offences can be divided into health and safety offences, emergency situations, incidents or accidents, employment rights, and compliance issues. So the highest profile criminal prosecution we had to assist a member with was in 2005. He was a mate master on the Cook Strait ferries, and at that time the regulator was in the midst of a campaign of criminalisation of ferry masters. So the Cook Strait rail, passenger and cargo ferries are part of the integral infrastructure of New Zealand, and therefore they're highly political. The news media is constantly putting them in the spotlight, and they've always been strongly unionised. So this mate master was exiting one of the channels in South Island, coming into the Cook Strait, when the ship was affected by a strong tide and came dangerously close to the land. There was no damage or injury to passengers or crew, and yet he found himself facing 3 criminal charges. 2 of the charges were for operating the ship dangerously, and the penalty for those was 12 months imprisonment and or a fine. And the third charge was for failing to report the incident. So the union instructed counsel and brought 2 expert witnesses. They were both ex-ferry masters, and the mate master was acquitted of the dangerously operating charges but not of the failure to report charge. So even though liability for that charge rested with the master of the ship, and he was the mate master, he was still convicted. So the union appealed that decision to the Court of Appeal but lost it, and he was ultimately fined, but only around $800. He was also demoted by his employer, and so soon after that he resigned, and he now works in the offshore industry. But the case was heard in the High Court and the Court of Appeal, and so it was a very costly one, around about 60 to 70,000 New Zealand dollars altogether. And the union was able to recover most of that cost from the employer via indemnity clauses in our collective agreements. The next criminal case I want to mention is not one that related to our members, but to the Filipino master and second officer of the vessel MV Rena, one of the flag of convenience container ships plying New Zealand's coast, and which grounded in New Zealand waters in 2012. The vessel was racing to catch a 3 a.m. berth at New Zealand's busiest port, Tauranga, but crashed into the Astrolabe Reef near the harbour entrance, a known navigational hazard, and grounded, spilling fuel, containers and debris onto the New Zealand coast. The quantities of fuel were very tiny, but the event was described as the worst maritime disaster in New Zealand's history, and there was a huge media frenzy with hundreds of people on the beaches at Tauranga cleaning up the oil and saving the wildlife. The crew were left on the grounded vessel for 6 days, terrified, with the vessel rolling around, creaking and threatening to break up. The decision by the regulator to leave the crew on board for that length of time appears to us to have been punitive in some way. The P&I Club took responsibility for looking after the crew, and the 2 men who were charged were given name suppression and remanded into custody at a secret address in Tauranga, and the P&I Club arranged for and paid for legal representation. During the investigation, the men admitted they didn't have current charts for the area, and that after the grounding they had falsified the records to try to conceal what had happened. They were charged with offences under the Resource Management Act, the Maritime Transport Act and Crimes Act. That was attempting to pervert the course of justice by falsifying the records. The sentencing judge told them that they had been charged under the Resource Management Act because under the technical definition they were regarded by that act as the owners of the vessel and therefore strictly responsible for any discharge from the vessel. They pleaded guilty to the charges and were given prison sentences of 7 months each. They also met with local Indigenous tribe members to apologise for the damage caused. So in this case there was clearly some culpability and some possibly recklessness, but with no loss of life, a prison sentence in our view was not warranted. It was not the ship owner who brought any charges against its officers. Indeed, those officers both kept their jobs with Dana Shipping. It was Maritime New Zealand who prosecuted. Some say that was to divert and to cover up its own total and shocking unpreparedness to deal with such an event. But it was also clear that the master was affected by commercial pressure and that the treatment of the seafarers in leaving them on board dangerous wreck for so long had been unfair. The men were given name suppression, and it was the P&I Club who gave the most assistance to them. In the union's case, legal representation where it's required is given on a case-by-case basis. Advice on the right to silence and fair treatment as part of the representation. We have the indemnity clauses in the collective agreements which provide for reimbursement of legal costs for employees, including defending against criminal charges. The indemnity doesn't cover criminal liability, so if the person is convicted, the costs can't be recovered under those circumstances. And we instruct our own solicitors, McBride, Davenport, James. They're listed on the Jason Legal Advisors list, and they're employment and maritime specialists, or we will be referred to a criminal law specialist if necessary. For foreign crew, it's either the national flag or Labour Supply Union might be contacted to provide representation if they're not available or not responding. The P&I Club obviously has helped with a recent foreign crew conviction. And at times we have got the crew members to sign power of attorney for us to represent them. So that's one other avenue. So in summary, criminalisation of our members has at some point been quite a concern for New Zealand, but it remains to be seen whether the regulator's new director and board will follow the same path as had been followed in 2005 and that period. But treatment of the Filipino master and second officer was unfair and the prison sentence was unwarranted. So that's just a small glimpse of our concerns and involvement with criminalisation. Thank you for listening. Hope you have a lovely dinner tonight, and I wish I was there with you. Bye.